Welcome back. Will Worsham joins us now for this week's Speaking Legal discussion, where we answer yours legal question on air. Good to see you again, Will.
You too, Tom.
All right, we're going to take a look at this week's question. I lost my job and could no longer afford my court-ordered child support payments. Should I just pay what I can and hope for the best?
Well, paying what you can is a good idea, but not paying your court-ordered child support can create several problems. One, if it goes long enough and it can be shown that you had the ability to pay, it can actually lead to criminal non-support charges. It can actually be a felony charge. You can go to prison for not paying your court-ordered child support payments. But in a situation like this where there's been a loss of job, you can apply to the court for a motion to change the child support amount. You have to prove certain things. The main thing you have to prove is that there are substantial and continuing changed circumstances. So, you know, a temporary downturn, a temporary loss of income might not rise to the level that a judge is going to change the child support amount. But if you can show that this is a permanent, semi-permanent situation, and that it's continuing and that it is significant, then you can get that child support amount changed or modified.
What is the process to go through? What is it? I'm assuming you need an attorney to do that. Does it cost you to get through that process, or is this something you can just go file on your own?
Well, you, like almost anything, you can try it yourself. It's probably not going to be likely to be successful without some specific knowledge. You have to file a motion. So you have to draft a legal pleading that says this is a motion to modify the child support payments. These are the reasons. This is why. There's specific things that need to be alleged in that motion. Then it comes up for hearing. There can be evidence and all that stuff presented, and then you have a spouse on the other side, or an ex-spouse
who has a lawyer.
Who has a lawyer. So it can make
I'm seeing a hole in that do-it-yourself kind of thing.
Well, and a lot of times, you know, there can be responsive pleadings, because on the flip side of that too, you can file a motion if there's substantial and continuing change circumstances. You can modify the custody arrangements on that basis as well.
So things are still negotiable. Just because there's been a court-ordered decision, that doesn't mean it is absolutely etched in stone. Well, things change.
It can be modified. There are certain things that are non-modifiable, and certain things, if the decree is written that such and such part of it is going to be non-modifiable, then it's going to be non-modifiable. Child support and child custody arrangements are almost always subject to modification, because once again, when you get into that area like we've talked about before, the standard is what's in the best interest of the child. And so no court wants to etch in stone something today that 10 years later might not be in the best interest of the child.
What if someone's income goes up on either side of the equation?
Once again, yes, you can file a motion again to change the child support amount if there's substantial and continuing changed circumstances. So like child support is calculated on a percentage basis, and there's some other little things that figure into that as well. So if there's a significant change, it's going to change the percentage, let's say the wife's income or the custodial parent
they win the lottery.
Income goes way up, then that can change the amount of support that the other parent might have to pay. Or if the obligated parent, the one that has to pay support, if their income goes up dramatically, then the custodial parent, the one that's receiving the support, can petition the court and say, no, well, they should pay more towards the support of their child, because once again, it's what the child should get.
And I think the message here is do something. Don't just let it lapse and hope for the best.
Don't just not do anything and not pay, because you're going to get yourself in a lot of trouble doing it that way.
Now you have something coming up where people can find out all about so many different issues.
Next Tuesday, we're having a divorce and family law seminar. It's over the lunch hour, so people can come. We won't start the program until about 12:15. Register online. There's supposed to be links at ozarksfirst.com, Facebook page, and things like that. $20. Lunch is included. We'll go from about, like I said, 12:15, we'll talk for maybe 20, 30 minutes, do a presentation, and then have a time for questions.
Nice.
So you can ask some questions, get you back to work on time.
All right, and if you have a legal question for Will, you can email him at wworsham@color10.com, and we will answer your question on the show. Will Worsham, as always, thanks.
Thanks, Will.
Thank you.
All right, we're going to take a break. When we come back, this week is Bike to Work Week, and the guys at Queen City Cycle show us how to get your bike ready and told me about a special ride coming up. We'll show you that after the break.